Hi, everyone. Harry here to talk advice of counsel. It's going to be a really important focus in the upcoming January 6th trial concerning January 6th coming in the spring and before Judge Chutkan and the Department of Justice. The special counsel made an important motion about it yesterday. Okay. This is a pretty misunderstood defense, and it's a lot harder to make than people think. We've had over the last year representative after Representative Trump casually say he relied on counsel and, it's not his fault. But it ain't so easy, nor should it be, right? You can't just, get up and make it up or say later unless you've really made certain prerequisite showings. So first, you have to show that you, in fact, did rely in good faith on counsel. It's not good enough to, go and get some piece of advice from any old schlub out there and seize on it, but rather you really believed it. Okay. Now, for Trump, the advice of counsel he's going to want to rely on is going to be precisely from one among the team crazy who had his ears at the important November, December time period, precisely because they would tell him the crazy stuff that he wanted to hear, right? So you can't take 20 lawyers and get the right advice from all of them, and then the 20th, says to, oh yeah, whatever you say, boss. You certainly, the 12th Amendment says that Mike Pence can just decide what the electors are, et cetera, because that's not good faith reliance. That's just exploiting the attorney-client privilege. So you're going to have to show all these things. And you're also, the other big showing you have to make is you gave the lawyer all material facts before you did. So you can't call up a lawyer and say, yeah, I think I was around the bank, but I never went in. But it turns out, in fact, you're driving the getaway car or whatever. You need to know the advice because you're going to have a lawyer, a credible lawyer, who's going to get up and say, I gave him this advice, yes, and it was based on all the facts. And if it turns out, well, did the defendant tell you, in fact, he was in the getaway car? No, that doesn't simply make the defense less persuasive. It blows the defense out of the water because you have to make these showings first, okay? And in order to do it, the most important corollary here is you waive all attorney-client privilege for all communications having to do with the counsel that you got here that you supposedly relied on and anything else that could undermine it. So all the lawyers who are telling him you can't do that and that's illegal, all the grown-ups, remember, we're a team normal versus team crazy, and everyone in team normal, Pat Cipollone and Pat Philbin and Bill Barr, he got all kinds of advice that he can't do that. That has to be waived and given over to the prosecution to undermine or fight his ability to assert it in the first place, to say to the judge, he hasn't made this showing, so he shouldn't get, foot out of the door on advice of counsel. Or if for some reason the judge says he can present it, the United States is entitled to that information to undermine it. Oh, really? Well, isn't it true, Mr. Trump, that you also were told this, say, by the White House counsel, and that, say, by the Attorney General? And that leads to another point, which is in order to show good faith, I think it's got to be, I don't see how he does it without testifying himself, at least not in front of the jury, but to establish it in the first instance. But then if it's permitted, I think in front of a jury, and we're now at Axiom 1, Donald Trump can't testify. So I think there's thinking kind of casually you can just somehow put up a kind of riddled with errors and not fully informed by the facts kind of opinion by a crackpot like Sidney Powell and John Eastman. Not only is that a lousy advice of counsel defense, it's not advice of counsel at all. So the motion that the United States filed yesterday was to say, hey, if somebody asserts advice of counsel, we have the right. He's got to waive, give us all this stuff, show that in fact he relied on it and the like, in order just to assert it. Now, we think we should get that information around the same time that all the kind of pretrial motions are coming to an end, by December 18th. Please, Judge Chutkan, order the defense to give us this information. Now, and that's the immediate skirmish that's going to be going on. There are some, a lot of courts have done it in just that situation. Some courts have said, well, that's really going to prejudice the defendant because he may not actually do an advice of counsel defense, and unless he's going to, that's giving away a lot of information. But the United States is saying in its filing, it's crystal clear. He's telegraphed it in 18 different ways. That's really not a mystery here. So you don't have to pay attention to courts that have cut defendants slack to not produce the information on that ground. Since it's here and since we're going to have to prepare for it, order him to do it by December 18th. So that's the immediate dispute that's been teed up. It's a very reasonable request and one that most judges would grant, and I expect Judge Chutkan would, but it's one that will be, I think, an insurmountable headache for Trump. I just don't see how he waives all the information and provides to the United States everything that tends to undermine supposed counsel. And I'm not even sure, of course, we don't even know what it's going to be. There are all these different candidates. Were they even his lawyers in the first place? So we want all the information that goes to show they were or they weren't. And then everything people told him and what was the exact opinion. And are there lawyers out there who, has Eastman or Chesbro or whatever really written something we haven't seen yet that says, oh, this is fine, go ahead, or will it be some kind of lawyerly hedged? If the electors are already in there fighting in court, well, that would be okay, but they're just contingent. Some opinion like that wouldn't count because it's not the opinion he's relying on. It's not based on the full facts, which maybe weren't disclosed to them. I think, especially since they're defendants, having any of these lawyers say, oh, yes, I knew everything and I told him exactly this unlawful cause of action is unlikely. And I think it's very unlikely for him to show that he proceeded in good faith. So if Chutkan actually grants this request, and the next thing that's going to happen is they will oppose it, you're going to see, all kinds of scrambling and protests and let us try to do partial. But I just don't see how Trump can provide all the information he needs to in order to invoke attorney-client defense. And then the right ruling by Chutkan will be not go ahead, have your chance with the jury, but no, forget about it. Unless you make these preliminary showings, you may not present an advice of counsel defense. It's the kind of argument that she'll be very careful about because it could be a rich issue on appeal. I wasn't permitted to present my defense. That's, the kind of thing that captures the attention of a court of appeals. But what Trump is doing is the kind of thing that rogue defendants do all the time, trying to get away and claiming advice of counsel when the counsel really didn't give full advice based on all the facts and when the client really didn't rely on it in good faith. So this is almost a microcosm of the trial to be, and it will be, I think, quite a brouhaha if she grants the motion. That there won't be much that Trump could do to appeal that, but then come payday, December 18th, seems to me there's going to be no way he can make that full showing, will make that full showing, and there'll be subsequent fights that will serve up to Chutkan the request from the United States. You know what? He hasn't done it. Just ban him. Just say this is not a defense he can present in front of the jury. And I think that's where things might be trending. That would be an awfully consequential ruling, but it seems the right one. Trump, to me, seems someone, a classic rogue trying to invoke advice of counsel under circumstances when the law really doesn't permit it. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.